All right. Good afternoon, everyone, and thank you all for joining us for today's a month of service presentation of inherited property, clearing title, deferred property taxes, and other probate concerns. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation. We are one of the partners in the a month of service collaboration. Also included, we have the City of Houston's Department of Neighborhoods, and presenting today, we have Ms. Lisa Nelson with the Texas Legal Services Center. Also presenting is the Harris Central Appraisal District and we have Miss Mabel Menifee and her team here today. Also with the Harris County Tax Assessor Collector's Office. In addition to that, we also have Lone Star Legal Aid, Houston Volunteer Lawyers, and the Earl Carl Institute, and we all make up a month of service. And basically, what a month of service is the collaboration of all eight of our organizations coming together on a monthly basis and offering a variety of different workshops, resources, and information to the community relative to asset protection, the maintaining of generational wealth, asset building, and community empowerment. We know that there are a lot of underserved communities that are out there that don't have access to a lot of information, don't know where to go for available resources. So we decided to collaborate several years ago, combine our efforts and our initiatives, and try to create a larger impact and reach more people by combining our resources and making sure that we try to get as much information out to the community as we possibly can. So we used to be in person in various communities around the city for an entire month, and then we go to another area and stay there for an entire month with a variety of different workshops. But now, of course, we're transitioning to the virtual platform, and now this has allowed us the opportunity to actually reach even more people in surrounding counties throughout the state of Texas and even across the country in a lot of instances where people are joining in and watching the presentation. Do know that the information that does get presented here is for educational purposes only. Nothing here is considered to be legal advice. However, we do encourage you to reach out to any of our legal service partners or to our presenters if you have questions in regards to your particular circumstance or your need. But you do have the opportunity to ask questions by typing it into the chat. Or if you're joining us on our social media platforms, then please feel free to type your question into the comment section, and I'll make sure that it gets read aloud at the end. Do keep in mind that we are recording this session as well as broadcasting live from our social media platforms. So we do ask that you try to keep your questions to be as general as you possibly can. If you do have a personal or particular issue in regards to your particular circumstance, please address it to the correct person in the chat, or provide your information, and they'll give you the contact information of who to contact or how to get that particular issue addressed aloud. We want to try to protect your privacy as much as we possibly can, as we are on a public platform. We don't want your detailed information kind of getting out there for everybody to have access to or to know, especially if you're mentioning, somebody passed and they left this property to whomever, or, we have these, heirs and these are their names and I live here. We don't want you to give out any kind of information like that. So do keep that in mind. So with that being said, there's a lot of information that's going to be covered here today. We know that there's a lot of folks that are still out there that are having issues with heirs property, really unaware of what heirs property actually is and what does it mean when someone passes away without a will. But we're going to get into all of those details for you today. And hopefully you'll walk away with a lot more information or guidance and direction of where to go from here if you are addressing some, or if you are facing some kind of a concern. So with that being said, we're going to go ahead and have our presenters introduce themselves and introduce their team, and then we will move right on into our presentation. So, Ms. Mabel, why don't we have you introduce first and the team, and then Ms. Lisa will have you introduce last, and then you can move right on in.
Sure. Okay. There we go. Good afternoon, everyone. My name is Mabel Menifee, and I'm with the Harris Central Appraisal District, and we work with the Texas Legal Services to present this workshop regularly. And one of the reasons is because as you go through the process of clearing title on inherited property taxes are often an issue or something that the heir or person purchasing the property needs to be aware of and sometimes they aren't. So, or how that all fits into clearing title on property. So we're going to be talking about that a little bit later on after Lisa's presentation. And fortunately today I have members of our team who are content experts in things like exemptions and appraisals, and they can help you with answering any of those questions that may be related to your issue with clearing title. So I look forward to speaking with you a little bit later on. Thank you.
Okay, and I do believe that that Shay Pinkowski came in. Shay, are you there?
I sure am. Can you see and hear me okay?
Yes, ma'am.
Awesome. All right. Hello, everyone. My name is Shay Pinkowski, and I'm here to speak on behalf of the Office of Annette Ramirez with the Harris County Tax Assessor Collector's Office. Our office is the department that handles the actual collection and disbursement of the funds for the services that we use as a community. So I'm super excited to be able to answer some questions and hopefully assist with any questions that you might have regarding your property. And as Ms. Nia mentioned earlier, if you have questions about your property, which are personal in nature or have your personal information, we do recommend kind of keeping those until, at a time where you can speak to one of us directly as opposed to on the public forum. But I do look forward to being able to speak with everyone here today, and I look forward to be able to help you with questions.
Okay. Tawana, did you want to introduce, or did she introduce everybody?
Hi, my name is Tawana Nelson. I am an exemption specialist here at the Harris Central Appraisal District. I'll be here to assist you with any questions you have, well, any general questions you have regarding exemptions. Otherwise, I'll direct you to our department in order to get specific information.
Okay, Ms. Lisa.
Good afternoon, everybody. Thank you so much for joining us today. My name is Lisa Nelson, and I am one of the staff attorneys on texaslawhelp.org. We're at Texas Legal Services Center. And I'm here today to talk about clearing title, mostly clearing title to airship property, but also any other probate concerns you might have. This is a follow-up to the presentations that we give on how to do your own estate planning and why you need it. And I'm here to show how it works once you are all set up. I will be speaking for the beginning, and then I will hand it over to Miss Mabel and then Miss Shay to talk about tax concerns, but I will be keeping an eye on the chat, and I'll be available at the end for questions. So thank you. So I'm here for clearing title and other probate concerns, how to handle inherited property. So we talk about airship property all the time. Airship property, inherited property. I've also heard people refer to it as family property. In general, we're talking about property that has been in your family for several generations and making sure to protect that generational wealth. So I will give you an overview about probate in general, and then I'll tell you about the practical ways in which you can clear title to any property that you may have inherited. And then we want to make sure that once you get your title cleaned up, that your family members don't go through the same experience. So we'll talk about how to make sure that things go smoothly for future generations. And then I'll pass it on to Harris Central Appraisal District to talk about property tax issues. I'm an attorney with Texas Legal Services Center. We've been around since 1981. We are statewide, even though I'm located in Harris County. And we have about a dozen groups that provides legal advice, advocacy, representation, and education to underserved people across the states. Our programs touch pretty much every aspect of civil law that affect low-income Texans. Our mission is to ensure justice for all. Here's my email address. I'll put my contact information in the chat later as well. I will not be looking at the chat while I'm presenting, but I will run through it. And Miss Nia also does a great job to make sure we don't miss anybody's questions. So I like to start with the new vocabulary that you will learn as you're dealing with the probate after you've lost a loved one. A decedent is another name for the person who passed away. If you hear the term testate, that means someone who died with a will. Intestate is someone who died either without a will at all or without a legally valid will. A testator is a person who has a will and there's two ways to define a testator. You're called a testator when you're actually signing your will in the lawyer's office. You're also the testator is someone who has a will in place when they pass is a testator. Will is simply a legal document that states how the testator's property is to be distributed at death. It's how that person's last wishes are expressed. Estate is your stuff. It's the property, both real and personal, owned by the deceased person at the time that they pass away. Probate is the name for the courts, as well as the process of winding up a person's affairs. You will still go through the probate process, but if there is no will, it's called administration. One of the major purposes of probate or administration is to have a personal representative appointed. That person is known as an executor if there is a will, an administrator if there is no will. And that's the person who's in charge of wrapping up the affairs and making sure that the heirs get everything they're entitled to. Heir or beneficiary are interchangeable words. That's the person who inherits either through a will or by law. I have been giving this presentation for a while and I still run across these mistakes. We were really fortunate to have an in-person event a few weeks ago and I had someone come up to me and say the same thing. Powers of attorney are only valid when someone is living. Once that person is passed, the power of attorney is void. If someone passes away and they do not have a will, you as the power of attorney still have no authority. That is only valid while they're alive. Everyone thinks that if they're married, the house is shared equally. That may be true, but if you married someone who owned a home before the marriage, that might be considered separate property. The surviving spouse has a right to live in their house until they pass away. That's called a life estate. They are responsible while they are living to pay property taxes, and they are responsible for maintaining the property. When you name an executor, or if the family chooses someone to be an administrator of an estate, they are not legally qualified if they're under the age of 18. And if they live outside the state of Texas, they can get qualified, but it's more difficult. It's very important to know that if the executor cannot find your original will, Texas law presumes the will has been revoked. That's why when I have people sign wills, I make sure they sign in blue ink so you can tell it's the original. It is very important that your executor know where your original will is. It's really important to have an attorney prepare your will, or at least take a look at your will. I come across wills all the time that had the best intentions, but they're not compliant with Texas law. I do not recommend using, LegalZoom used to be the only one. There's a new program called Will and Trust, programs where you can get a free will off the internet, or it's $100 for a will. Those wills may not be valid. The one exception, the Texas Supreme Court has approved forms for people to do their own wills. You can find them on our website. It's texaslawhelp.org. Spouses must have separate wills. You can't have one will signed by both spouses. They each have to have their own. You know, as much as I say that it's really important to have an attorney look at your will, in Texas, you can write your own will. You can use the forms that the Texas Supreme Court approved. You can also have a will that you've handwritten. It has to be completely in your own writing. It's known as a holographic will. You can go, if you are ill and you want to get a will in place as soon as possible, go to texaslawhelp.org and we have directions on how to do that. As I said earlier, please keep your will in a safe place where at least your executor or maybe other friends or family members know where it is as well. If they can't find your will, it's as good as not having one. If you die without a legally valid will, the law determines who will inherit your property. It will not go to who you want. It goes to who the law says is next in line. Now, if your loved one has passed away and you cannot locate a will anywhere, or it's a will that you realize might not be great, you can file an application for administration. If all of the circumstances are perfect, you can file for independent administration, which is not much more complex than having a probate of a will. If there is a child involved, or if your heirs don't cooperate, they will have to file for dependent administration, which is a very slow and expensive process. There is a very limited procedure called a small estate affidavit, which I will discuss in a few minutes. In Texas, a lot of people get frustrated because you have to have an attorney to probate a will or to file for administration. It is one of the reasons why it's really important to have an attorney is because there are so many different processes, and the attorney can determine which is the not just the best, but the most cost efficient, the least expensive, the easiest way to settle the estate. Texas has what's called ours probate and non-probate. Probate assets are property that pass under a will. That would be any real estate that you own, as well as your personal property, such as your furniture, your clothes, your car, all of your household items. Non-probate assets have nothing to do with your will. They pass in accordance with the terms of a contract. So they have nothing to do with the will. They have nothing to do with probate court. Examples of non-probate assets include life insurance proceeds, the retirement plans, and payable on death accounts. My favorite tip to give in this class is if you have payable on death beneficiaries on your financial accounts and a transfer on death deed for your home, your family may not need to probate your will. You absolutely always want to have a will because there's a chance that there's an account out there that you have forgotten. There's a chance that there's something else out there that you don't realize needs to go through the probate process. But, take some time this afternoon or tomorrow, check with all of the financial institutions where you have an account, and make sure that you have payable on death beneficiaries. Make sure the names are correct. If the names are not what's on their ID, for example, if they've gotten divorced, if they've changed their name for another reason, if they've gotten married, if they don't have the correct name on the transfer on death, they will not be able to get it. So you want to make sure that's correct, but there's a good chance that you can get away without probate in Texas. Small estate affidavits are the only procedure that in most Texas counties you can do without an attorney. However, they are only appropriate in extremely limited circumstances. You can only use a small estate affidavit to transfer property if it is a surviving spouse or child under the age of 18 who's going to inherit the home. You cannot use a small estate affidavit if it is an adult child who was living with you, an adult child who was your caregiver. They cannot inherit a home through a small estate affidavit. Also, the deceased person cannot have left a will. All the heirs must sign the small estate affidavit along with 2 disinterested witnesses. So that means anyone legally entitled to inherit from you, as well as 2 people who knew your family history well and who can swear under oath that those are your only heirs, will all have to sign that form. So if people are not getting along, a small estate affidavit will not work. The other issue with a small estate affidavit is that the value of the assets have to be greater than the debts of the estate. So say you have, and this does not include the value of your home. So you have a home and you have, say, $35,000 in property, but you have $50,000 in debt. The judge will not approve the small estate affidavit. Also, the full estate, everything that you own except for your homestead, has to be less than $75,000. This goes through the process of probate very quickly, but just so you understand what happens, if you're probating a will or if you're filing for administration, what happens is that the attorney begins by filing an application with the court. After the application has to be on file for 10 days before the attorney can schedule the hearing. This does not mean that 10 days after the attorney files the application, you get to go in front of the judge. I'm not sure about current dates, but in Harris County, it's not unusual to wait 6 months or more before you are able to have the hearing to admit the will to probate. The courts are just that busy. It's a very simple hearing where the judge reviews the will, the judge reviews the statements of witnesses and the attorney, and then the judge will grant the application to probate the will. The judge, once the judge grants the application, if there's a will, the person receives letters testamentary. If there's no will, the personal representative receives letters of administration. The personal representative is in charge of gathering all of the assets. They also have to open a bank account for the estate. They can't mix the funds of the deceased person with their own. They will have to take the letters testamentary or letters of administration with a death certificate and a tax ID number to the bank, and then the banker will close the deceased person's account and allow the personal representative to open an estate account. Just because you are the representative of the estate, you are not personally liable for the dates of that estate. The debts are paid from the funds that the deceased person had. So the attorney notifies creditors, that's anyone that the deceased person may have owed money to. The creditors have to file a claim with the court that has very strict legal requirements. And then the attorney and the personal representative determine whether those claims against the estate are valid. Only at that time would they be paid if there are funds available. Finally, the attorney and the personal representative will prepare and file an inventory. That is a listing of all of the property that the person owned as of their date of death. Now we're going to talk about how to clear title to inherited property, which is a really critical issue in our community. A lot of people think that because there's a will, the property automatically is passed down to whoever was named in the will to inherit it. It is absolutely not true. You have to go through the probate process. If you don't have clear title, you don't qualify for any type of assistance if we have a disaster. And if you don't have clear title, you're not going to be eligible for property tax exemptions or deferrals unless you are the owner of the property. I say clear title all the time, and I realize that a lot of people don't know what clear title means. Clear title means that no one else has a financial interest in the property. Most importantly, it means that there's absolutely no question of ownership and that the ownership history of a property can be traced back. So I've had situations where family members had been living in a family home that was bought by a great grandmother, and there hadn't been any type of storm, so they didn't need to apply for assistance. They hadn't had any issues. And then something comes up and they realize they don't have clear title. The attorney has to trace back to where that purchaser had clear title and go through the chain to make sure that the property is handed down correctly to the people living in the property now. If property is not legally transferred or deeded to the subsequent owner, the title is called cloudy. This happens when someone passes without a will and the family, or in any situation where a family doesn't manage an estate. It's easy to get a confusion between title and deed. Title is just the legal right. It's not a document. It is just the legal right to own property. Deed is the piece of paper that conveys that right. Real estate title is the strength of your ownership claim, and having clear title means there's no unexpected claims on the property. A deed is the actual document that you record with the clerk that transfers the ownership to the new owner. It's really important to keep your title clear. I always recommend to people, if you've been living in a family home, an heirship property, once you get your title cleared up, you want to file a transfer on death deed, because that's the easiest and least expensive way to transfer property to somebody after they pass away. A will also transfer property after you die. It's just a longer process. It's really important to have clear title because you won't qualify for any disaster recovery assistance, property tax relief. Also, you can't get any type of loans. You won't be able to take out home improvement loans or other types of loans to your house if you don't have a clear title. One thing that was not unusual to run into when I help families clear up title to airship property is they find out that there's a lien on the house from, could be a repair that was done 10 years ago. It could be a loan they took out that wasn't paid off. So you want to make sure that your house does not have any type of claims on it. This is why, again, I run into all the time. People think that if there was a will, that's all they need to do. It's my house now, and that's absolutely not true. If you don't probate your loved one's estate, you may not have clear title on any real property, and also you may not be able to access any bank accounts. So there's several ways through the court system that you can clear title. When someone passes away, you don't have to do this right away, but within 4 years, you should either probate a will or file an application for administration. If it's been more than 4 years, you have to prove that there are very good reasons for it, but you can probate a will after 4 years as a muniment of title if you can prove to the court, to the judge, that you weren't delaying intentionally. If you have property that's been in your family for a long time, but it's more complicated, sometimes the original purchaser didn't have clear title. If you meet the legal requirements, you can file a petition for adverse possession. So if your loved one passed away within 4 years, you can probate a will or file an application for administration. To probating a will, the judge determines whether the decedent left a will compliant with Texas law. If there is no will or the will isn't legally valid, you can file an application for administration. If it's been more than 4 years, you can file an application for probate as muniment of title. There absolutely has to have been a legally valid will. And just like the process with the small estate affidavit, everyone entitled to the estate property has to agree to probate the will, even though it's been more than 4 years. It's a quick process. You get in front of the judge, you explain why you waited more than 4 years to probate. And if the judge sees that all the legal requirements are met, the judge will admit the will to probate, and then you can record all that paperwork in the county property office, and the person named in the will now be the homeowner and have clear title. Adverse possession is something people usually hear about. It's, lots of times what it is it's a lot next to a family home, and we've always kept the lawn up. We've always gotten mail at this address. Everybody knows that this is where we're staying. So adverse possession is a legal principle that allows you to obtain legal ownership of a property based on continuous occupation without permission for a specified period of time. It is critical that you did not have permission. I had situations where I was trying to get my client clear title, but no one else in the family would sign off on allowing her to be the sole property owner. So she could not qualify for adverse possession because they said, you can stay in the house for the rest of your life. I'm just not going to let you have the deed to it. So that person was not able to use adverse possession. The other issue is you have to have resided in that property for a significant period of time. Usually it's around 15 years. There's a list of requirements in the legal books that go through the details, and it will explain how much time you have to be there. This is a very common way to clear title. If it has been numerous years and the will has never been probated, or if there was no will, if you've been living in a house that a great-great-grandmother purchased, you can use an affidavit of heirship to clear title. An affidavit of heirship is a legal document that gives property to the heirs of a deceased person. This is another process that you do not need an attorney. We have the forms at texaslawhelp.org. The affidavit of heirship is basically a it's almost like it's almost like a family tree. It's a list of the descendants of the original homeowner, explaining who at this time should be entitled to have clear title to the home. The family members do not have to sign, but it has to be signed by two people who knew the deceased person and their family history well. The most critical thing is to have a full legal description. The full legal description is not the description on your property tax bill. You need to get the deed to the house to get the full legal description. If you cannot find a deed, you can reach the county clerk's office, and they usually can help you locate it. There's also a website called texasfile.com. It is a whole lot easier to use than the Harris County Clerk's website, and you can get your deeds from there, and they charge the same amount as the county clerk, which is $1 per page. The affidavit of heirship must be filed in the county where the property is located. There is a filing fee. It varies by county. Harris County is a little more expensive than the adjoining counties. And Harris County, it's roughly $45 to $50. The other counties can be a little less expensive. A lot of people get confused between a small estate affidavit and an affidavit of heirship. The small estate affidavit can only be used to transfer homes, can only be used to transfer real property to a surviving spouse or minor child. Those are the only two circumstances. A lot of people will make the mistake of thinking you can use a small estate affidavit for anyone. You will be out $400 because the judge will not approve it, and you do not get the filing fee back, even though you filed the wrong procedure. Another time that you can use a small estate affidavit is if the deceased person may not have owned a home, but they might have had some bank accounts without beneficiaries. You can use a small estate affidavit for that. Affidavit of heirship is the best way to transfer a home to a surviving spouse, adult children, or other transferees. That could be nieces, nephews, cousins, other family members that are within the line of inheritance. You can use an affidavit of heirship instead of going through the probate court if the home is the only asset that you need to transfer. Once you get your title clear, or even if you have a great clear title today, please make sure to transfer property correctly to your loved ones. Transfer on death deed is a really fabulous way to do this. It's simple, it's inexpensive, and it's a great way to transfer your home or other real estate to someone else upon your passing. The owner retains 100% ownership rights during their lifetime. So the owner can still sell the property, use it as collateral on a loan, qualify for property tax exemptions, etc. The beneficiary has absolutely no rights until after the owner passes. The owner can also change a beneficiary or cancel the transfer on death deed entirely. The deed is absolutely no good unless it is filed in the real property office at the county clerk's office in the county where the house is located. It has to be filed before the person passes away. So don't put the deed in, the safe location with your will. You want to make sure that it's filed. Transfer on death deed is another thing you absolutely do not need an attorney for. We have a great toolkit at texaslawhelp.org that will walk you through the steps with detailed instructions. Just like the affidavit of heirship, you need to have the legal description and make sure it's the correct one. So, if you don't have a deed in hand, please order one so that you can make sure you use the exact legal description. Otherwise, you're creating a cloud on the title. Transfer on death deeds are also terrific because you're protected from Medicaid estate recovery. If someone uses Medicaid to pay for their nursing home, once their surviving spouse passes, if there's a surviving spouse, Medicaid can seek reimbursement of all of the costs. That Medicaid can only get reimbursement if the house is transferred through the probate of a will. If you transfer the house through a transfer on death deed, they are not able to require to go after to recoup their investments. The Amos team has a lot of great partners who can help you. At Texas Law Help, we have information and forms for every Texas resident. We can also give legal advice to low-income Texas residents. Earl Carl Property Preservation, Lone Star Legal Aid, and Houston Volunteer Lawyers provide free legal representation to those who qualify. Always, always apply. Don't ever count yourself out because every program is different. Some programs have more flexibility in the cases they can take. Legal Line, which is a offshoot of the Houston Bar Association, allows anyone to get free legal advice from an attorney. They cannot take your case, but you're allowed to consult with an attorney. The Houston Lawyer Referral Service is another fabulous program. I recommend them anytime you're looking for any type of lawyer. One of the great benefits is you can get a 30-minute consultation with an attorney for $20. Sometimes that 30 minutes is all you need to have your question answered. But if you really like the attorney, you can go ahead and develop an attorney-client relationship with them. The Lawyer Referral Service also has a list of attorneys that will charge lower rates. They do fully vet the attorneys on their program, so you know that you're getting someone with good experience. Thank you so much for spending your afternoon with us. I am going to hand this over to Harris Central Appraisal District and Mabel, and I'll be back at the end for questions.
Okay, really quick also, Ms. Mabel, before you get started, I just wanted to let folks know that I did put the link for Texas Law Help's website in the chat, but do know that the resources, the information that she just went over and the forms of where you can get all those forms, I will be sending out copies of all those forms along with the link of this recording as well. So if you didn't get it or didn't catch it, you can go back and watch the video, but know that all those forms will be attached as well to the email.
Thank you
Right.
so much. And I just wanted to let everybody know, Monday through Thursday from 10 to 2, we have attorneys available for online chat. Like I said, we can give information and forms to anybody who's a Texas resident, and we can actually give legal advice if you're low income and meet our qualifications. So thank you, and I'll be back with you later.
Okay, Ms. Mabel.
All righty. Good afternoon, everyone. Again, my name is Mabel Menifee, and I am going to start the conversation off today as a follow-up to what Lisa talked about as far as clearing title. We're going to talk a little bit about exemptions. I have a couple of my colleagues on the chat with me today who can answer your questions as we go along, and then again we'll be able to answer any additional questions at the end of the presentation. I'm gonna do an introduction basically about HCAD and what we do there, and that's going to be followed up from my colleague in our information and services department and exemption specialist Tawana Nelson. We also have on the chat additional members of the team who can also answer your questions regarding any issues that might be related to appraisals. Now, one thing I do want to say, today we're mainly going to be focusing on exemptions. However, I can't ignore the fact that we're within a few days of the property protest deadline, should you disagree with the appraisals on the property that you currently own. We will have a special presentation, and we're going to talk all about property taxes and protesting here on Amos that we will be doing on May 14th at this same time. So if you have any additional questions now that you're listening about exemptions and what HCAD does, if you have any additional questions about that, please, I urge you to register for that presentation where we will devote the full workshop time to that, and also have some great content experts from HCAD to help you with that. So just continuing with our presentation today, I think everyone can see that. Is that correct? Are you guys able?
Do your swap presentation, click on
All right.
on the top. Yep.
Okay. Okie dokie. How's that?
Yes, ma'am.
All right, and then as I said before, I really want to just introduce HCAD and what we do. And then Tawana Nelson from our exemptions group is going to talk to you a little bit more in detail about exemptions and how they relate to clearing title on property. So HCAD really, we're the Central Appraisal District for Harris County. And what we do, there's one in each county, but we are the organization that supports local jurisdictions, taxing jurisdictions, and localities by appraising property and for property taxation purposes. And one of the reasons property taxes play such an outsized role in Texas is because we're one of those states that does not have a state income tax. So all of the revenue that's generated from property taxes are used to pay for those local expenses, like your school districts. They build roads, they pay for the police department, the fire department, etc. And property tax laws, all of what we do originates with laws, are embedded in state laws that originate with the state, Texas state legislature. We are the entity that's assigned with enforcing what the legislature has passed in terms of the tax code. We do have one oversight organization. The oversight organization for us is the Texas Comptroller's Office. Quickly, we talked about, property values, what HCAD does as Central Appraisal District. Again, we appraise all the property in the county, both residential, commercial, agricultural, industrial, and business personal, and we do so each year at what is 100% of market value, and that's the market value of the condition related to the condition of the property as of January the 1st of each year. The other thing that HCAD does, and one of the reasons we're here today, is that we administer exemptions. You will send in, if you qualify for exemptions, you will send that information along with an application into HCAD. If you no longer qualify for exemptions, you inherit a property that the previous owner had exemptions that they were entitled to because they were disabled or they were over 65, and none of that applies to you. Perhaps it's not your primary residence. Then you would also notify HCAD that you are no longer eligible for those exemptions, and then you would apply for any that you might be eligible for. So it's always important to remember that the exemptions, as we like to remind people at HCAD, belong to the person and not the property. So we also, again, we certify the appraisal rolls that usually in the late summer, which allows all of the taxing jurisdictions, so once they know what the certified appraisal value of land is in Harris County, they can then set their tax rates based on what their budgets are. So I mentioned January 1st. Very important to remember that that any condition on a property is based on the January 1st appraisal date. So in that case, and speaking in terms of inherited property, person passes away after January 1st, generally any exemptions on the property are going to be good for the rest of that year. It's the following year, now that the ownership has changed, that new exemptions would have to be placed on the property, or those previous exemptions for anyone moving into the property, they would no longer be eligible for. Also, I mentioned that we value properties, and there's always an annual date for deadline if you disagree with that value that HCAD has assigned to your property. And that protest deadline is usually May 15th. Could be later depending on when your notice, when it was mailed to you, but generally speaking, it's May 15th. It's always important to check that date on your valuation notice to be able to tell when your protest deadline is. It's always going to be May 15th or 30 days from the date that notice was mailed. Also, again, just in terms of the schedule, you get once HCAD finishes what we do and we apply all of the information to your records, the taxing authorities then calculate the bills, and the assessor's office mails those out, usually around the November time period. And then again, if property taxes are due on a property, then they are due by January 31st, or they become delinquent. So I mentioned just some additional things about HCAD. I'd already mentioned we value the property. Our values are usually derived based on sales within the area. We set the value based on sales. Responsible HCAD in Harris County, we are responsible for 1.9 million parcels and growing. And additionally, there are over 500 taxing jurisdictions in Harris County. You obviously don't pay to all 500. You may pay 4 or 5, but just depending on where you live, there may be different taxing jurisdictions. There may be a different school district or a different community college. So keep that in mind when tax bills are being mailed, and that means that you could be receiving more than one tax bill. This is just a copy of, I mentioned one of the things you get from HCAD each year, which helps you understand what the value of a property is this is our annual valuation notice. There's always going to be an appraised value and a market value on that notice. That's usually mailed this time of year, or usually mailed in early April or late March. And again, if you disagree with it, the date to protest it is always going to be 30 days from the date of that notice, right up here in that column across from property description, or May 15th. You saw on that letter the appraised value versus the market value, and it just sort of tells you appraised value is the value that you're going to pay, your taxes are going to be based on. And why is that? That's because of the exemptions and a 10% cap that you get if you have a homestead exemption. The market value is what HCAD determines each year. And the market value could be more than that, because that's the value a property would sell to for a willing buyer on the open market, which we've determined based on the sales that have already taken place within your area with a property that is very similar to yours. And it's important to remember too that, anytime you disagree with that, always remember, if you disagree with the market value, that those protests are going to be based on that market value, not on the appraised value, because appraised value factors in a lot of other things, and it's usually lower because of your exemptions. Quick summary of what you can do. We have a number of ways. If you want to protest, you can do that. Informal hearing, formal hearings. You can also do it online as well. And as I mentioned before, for anyone who is interested in protesting their property, we do have a number of workshops dedicated solely to that. And there's going to be one here on Amos that you can register for through NRC, through Neighborhood Recovery's website. That's going to take place on May 14th. And now I would like to introduce my colleague, Tawana Nelson, who's going to talk about those exemptions, and that will help you understand just how they may affect your property, as well as what needs to be taken care of in the case of clearing title on those properties. So Tawana, take it away.
Thank you, Ms. Mabel. Hi again. My name is Tawana Nelson. I'm an exemption specialist in our exemptions department here at the Harris Central Appraisal District. I wanted to go over the information for exemptions with you. Give me just a moment. I'm sorry. I'm trying to share my screen. Okay, so exemptions, what are they? How can they save me money, and how do I get them? Well, the exemptions are administered by the Harris Central Appraisal District. What they do is they exempt a portion of the property's value from taxation, and it's for your primary residence only. It's used by taxing authorities in calculating your property tax bill. The exemptions exclude part of your property from taxation, reducing the appraised value before tax rates are applied. The most common residential exemptions are the general residence homestead exemption, the over 65 exemption, the over 55 surviving spouse exemption, the disability exemption, the disabled veterans exemptions, and other service-related exemptions. The most common exemptions, again, is the general residence homestead exemption. You must own and occupy the home as your primary residence. The documentation will be required, which is proof of ownership and a Texas driver's license. It provides a 10% appraisal increase cap, which means that from the first tax year that you have your residential homestead exemption from January 1st, your total appraised value cannot increase by more than 10% from that tax year to the next tax year. It also provides a $100,000 school tax exemption by state law, and other exemptions may be offered by various jurisdictions, city, county, special district. It depends on where you live. The over 65 and disability exemption. For the over 65 exemption, you qualify for the entire year that you turn 65. It doesn't matter if you turn 65 on December 31st of that year, you will get the over 65 exemption for that entire year. The disability exemption, you also qualify for the entire year that you become eligible to receive disability benefits under the federal old age survivors and disability insurance. You can also provide us with a physician, your physician can provide us with a physician statement showing that you are disabled. The benefits for either exemption are the school district's taxing jurisdictions. They set what is called a school tax ceiling or freeze. That's an amount that your tax bill cannot go over if you're disabled or over the age of 65. The exemptions granted to homeowners with general residence homestead exemptions. You're also eligible for a tax deferral and to pay taxes in installments without penalties. Other exemptions may be granted by individual jurisdictions. You also have the over 55 surviving spouse exemption. You qualify if your deceased spouse died in a year in which they qualified for the over 65 or disability exemption. The surviving spouse must be 55 years of age or older on the date of death. You will receive all the over 65 exemption benefits. The school tax ceiling will continue and is transferable. You're also eligible for a tax deferral and to pay taxes in installments without penalties. The airship information that is contained here this is what section 3 of our application, the homestead application, looks like. The important questions are: is the property for which this application is submitted an air property? That's right here, the first highlighted question. You would check yes or no, and depending upon that first answer, do other air property owners occupy the property? And then you would check the appropriate appropriate selection. The information needed with your application will be an affidavit establishing ownership of interest in the property. This can be an airship affidavit or Form 50-114-A under affidavits. A death certificate for the prior owner of the property, a copy of the property's most recent utility bill, a citation of any court record relating to the applicant's ownership of the property if available. This is the annual exemptions confirmation card. You will contact us if the information is not correct. For example, if you're supposed to have a homestead exemption and an over 65 exemption, but you only see homestead on the confirmation card, then that means that your over 65 exemption is missing, and you'll need to contact us. We send this confirmation card out every tax year. Usually it's late December, early January that these confirmation cards go out. So if you do not receive your confirmation card, please give us a call to make sure that we have your information in our systems correct. how to apply. You can mail a paper form. You can apply through our website, which is hcad.org. You can use our mobile app or email. Depending on when submitted, the processing time may take longer. It's important to submit everything at once to avoid delays in processing. Once applied to your account, you will be notified. You'll receive a letter in the mail advising you of your exemption status. A how-to video is available at www.hcad.org. I think that's a forward arrow, forms, forward arrow popular forms. And you can follow along as you fill out the form. Be wary of solicitations offering designation of homestead for a fee. Acquiring the exemption is free to the property owner. We do not go through a third party to offer any type of assistance with the exemptions. We are here ourselves to assist you. We don't charge, again, for any type of assistance that we provide. The exemptions versus deferrals. A discount versus deferred, which means, okay, so with the exemptions, your exemptions give you a discount every tax year. It's a discount off of your total appraised value so that you can make your payments at a lower amount. The deferral is where you have an amount due on your tax bill. If you choose not to pay it and you have a deferral on your account, then you can make that payment at a later date. That payment does not, but it does not stop the payment from being due. It just stops you from being charged additional penalties. Our website is, of course, hcad as in David.org. We have made some changes to the website. Whenever you go to our website, there is now, hold on. If you go to our website, which is hcad.org, once you get there, you can click on Contact Us. And now there is a section that populates where you can request information from us and upload attachments and go ahead and send it in. If we sent you a letter and we requested additional information and you want to submit it, go ahead and go to our website, click on Contact Us, and you can submit your documentation through here. For some reason, I cannot find my presentation. I'm sorry. These are the best ways to contact us. You can come to our location, 13013 Northwest Freeway, Houston, Texas, 77040. We are open Monday through Friday from 8 a.m. to 5 p.m. Our general telephone number is 713-957-7800. Our web address is www.hcad.org, or you can go online and visit https://hcad.org/contact-us-form. Thank you for your time. I hope the information was informative. If you have questions, please contact us through the chat or contact us directly.
Thank you very much, Ms. Tawana. Now we're going to bring on Ms. Shay Pinkowski with the Harris County Tax Office, who's going to be kind of giving you guys some information about deferred property taxes and what happens when someone passes that's got deferred property taxes and how does that bill get paid? What's your payment options? But Ms. Shay, go ahead and take it away.
All righty, everyone. Can everyone see my presentation okay?
Yes, ma'am, you're good.
Fantastic. Alrighty. Hello, everyone. Good afternoon again. As I mentioned before, my name is Shay Pinkowski, for those of you who weren't here at the beginning. And I'm going to be speaking a bit about property taxes and how they are billed, collected, and then what happens to those property taxes, and some information about property tax deferrals and payment options that you might not be aware of already. So let's go ahead and get started. We have recently elected our newest tax assessor collector, Miss Annette Ramirez is a wealth of knowledge. She's been in the tax collecting, or rather the tax process for over 20 years now. She's a wealth of knowledge. She has lots of great ideas for the tax office. So we're super excited to have her. But she just got elected this year. So starting January, now you'll see your bills coming from Annette Ramirez as opposed to from our previous tax assessor. So there's some information there if you'd like to read up on her. As I mentioned before, she does have a lot of knowledge in the process of tax collection. So we're super excited to have her. So the tax office, the Harris County Tax Office, has a good wealth of responsibilities that we are in charge of and take dedication over, which include the collection of property taxes, which is what most of y'all are here to hear about, along with vehicle title transfers, vehicle registration. So the sticker, the plates that you get with your car is done by our office as well. And we also maintain the role of voter registration. So that's also something that our office does. Just as a note from our auto side, they did request that I mention that Harris County is still an emission state. So while we don't have to do the safety inspection, we are still required to go through the process of getting that emissions test done. So whenever you go to renew your registration for your car, make sure that you have that emissions test and that you bring that in whenever you come into the office. But they did ask that I make a notation of that because it is a very common question. We don't want you guys to, have to worry about that whenever you come into the office. So just as an overview, the Harris County Tax Office collects property taxes for approximately 1.7 million property accounts, which adds up to be about $8 billion in taxes every year. We disperse to over 80 jurisdictions, which mean that we disperse that funds, those monies, that tax amounts that we as residents pay, that all goes to jurisdictions including the Harris County, Houston ISD, City of Houston, flood control, along with multiple mud taxes, emergency services districts, and these are all processes and needs for the community that we pay for collectively through our taxes. We don't have a sales tax in Texas, so all of these processes are paid for by your property taxes. So just as a quick overview, those are the numbers that we're looking at when you refer to the Harris County Tax Office. It is one of the largest collectors in Texas, so just so you're aware of how big the county that we are in is. There have been a lot of changes in the past couple of years, most of which have reduced property taxes for the greater population of Harris County, including an increase for the over 65 and disabled exemptions on Harris County taxes. That exemption went up from $229,000 to $320,000 over the last 4 years, which means that that's how much your taxes get reduced when you have that over 65 or disabled homestead exemption on your property. City of Houston's exemptions had increased as well for their over 65 and disabled exemptions, and that went from $160,000 to $260,000 in the last 4 years. Your school, the state of Texas has mandated that the general homestead exemption for your schools be from 4 years ago at $25,000 to $100,000 this year, with possibility of it increasing even more this upcoming year, but that's going to be decided later. Your homestead exemption has become available for prorated start date, meaning that instead of having to wait for the first full year in which you own your home to have that homestead exemption placed on it, you are able to have it for whatever portion of the year from the date that you move into the property, instead of having to wait for that first full calendar year, which helps people save a lot of money, because if you move into the property early but not at the beginning of the year, previously you weren't able to start that homestead exemption until the first full year. So even though it's not over the entirety of your first year as a property owner, it has reduced it by a great bit. So it can be very helpful for folks that are moving into the property for the first time. Now, if you're used to seeing your property tax bill, this is what you're used to seeing it look like. It would normally come to you from October to November every year and would be due at the end of January. That bottom portion of your bill is your property tax coupon. And that is what you would normally submit in or have with you whenever you come in to make your payment to one of our offices. And it includes that barcode, which helps us to be able to locate your account easily without having to worry about, forgetting a number or possibly typoing an address. But this does help us locate your account really quickly. And it's something that you would send in whenever you make your payments. The top portion of the bill itself would include information such as which jurisdictions are applicable to this property, the values of your property taxes, which exemptions are applied to your account as per what we have in our system, along with penalty and interest if incurred in the future. It'll give you the month in which each penalty and interest would be applicable for, so that you're aware of what your situation would be if you are unable to pay your full property taxes within that first month of January. So this is what you're used to seeing whenever you get your property tax bill. And so long as we have that coupon there at the bottom, or if you have your full account number or address, we will be able to locate that account for you. In addition to receiving your property tax statements through the mail, there is another option available to property tax owners here in Harris County, and that includes electronic statements. So if you have an email and you would prefer that instead of receiving a physical bill to your address, that you receive it to your email, that is an option that you can sign up for through our website. And it's something that you can register for. Now, do keep in mind, this is instead of the paper bill. So if you sign up for electronic statements, you would not be able to expect a mailed bill to come to you. So if you choose one, you would not be able to do the other. But an alternative to that is if you go onto our website, you can also search for your tax bill online as well. So even if you haven't received it in the mail, if you're just really anxious to get that bill seen and sorted, then you can go online and retrieve it that way as well. And usually, again, that starts around October, with some differentials depending on when your tax bill was certified. So the method in which we collect, or the method in which we calculate your property tax bill, is by using the taxable value of your property. And the taxable value is the appraisal value minus any exemptions that are applicable to your property as per what's approved by the appraisal district. That's your taxable value. We multiply that by something called a tax rate. And the tax rate is determined by each individual jurisdiction. They all select their own and calculate it based off of their needs in order to meet the maintenance and operations of each of the jurisdictions. So in order for them to continue to do what it is that they need to do, they calculate a rate on which they can attain those goals. And we multiply those two together to create your tax bill. So whenever you're looking at your actual bill, that very top portion of your bill, you'll see the amount that the property was appraised for, which exemptions are being applied, along with the rate at which the jurisdiction is collecting your tax. And you'll see how much each individual jurisdiction is collecting for property taxes. And then that all adds up to your tax bill. So you'll see a good couple of line items on your bill, and that is due to the jurisdictions that are applicable to your property. A homestead exemption, we discussed this a little bit earlier, but just so you can see how much of a difference it can truly make to have an exemption on your property versus not having any exemptions whatsoever. These numbers are all based off of an approximation of the average value of a property in Harris County, which is $342,000. And without any exemptions for homestead property, for Harris County property, you would be looking at a tax bill of approximately $7,155. With your tax savings for a homestead, you would have a reduction to that of about $2,000, which would result in a bill of about $4,866. When you add on top of the homestead exemption an over 65 or a disabled exemption, that can be reduced even further because you're having higher exemptions on your property, and that results in an even lesser bill of approximately $1,591. So these are all based off of those average properties with the homestead and with an over 65, but you can see what a difference it makes to have those exemptions on the property versus if it's applicable to you, but you don't apply for them, how much more you're paying for your taxes needlessly. So it's always important to make sure that you're on top of your property tax information. And if you are eligible for any of these exemptions, that you go forward and apply for them in order to get those tax bills reduced. In addition to our usual exemptions that are available to our property tax owners, there are also certain circumstances in which we are able to do something called an assistance for damaged property in a disaster area. And normally these are in reference to, state and disasters that happen and occur in Harris County, that there are situations like hurricanes, tornadoes. Unfortunately, we do live in an area that does get hit by storms quite often. We are susceptible to flooding. But that assistance for damaged property in the disaster area is as an exemption to the property that is damaged, or the percentage of the property that is damaged. So that's something you can apply for with the appraisal district, and it's something that you'd like to keep in mind for future reference. Right now, we're not suffering through any of these things, thank goodness, but there has been some pretty bad flooding up in like a UT area over College Station. So this is the kind of thing that they would be taking into consideration for that if it's something that the governor approves. But it is something that you'd like to include photos for, along with any estimates for repair, or any other kind of information that you would have that would be able to show what the damages caused were and how much it would cost to fix, in order to be able to reduce your taxes a bit for during that time period. Something that you'll hear a lot of people speak of once they turn over 65 and have that exemption placed onto their property is something called a tax limitation. They'll go by a lot of names. Some people will call it a tax ceiling. Others will prefer to use the word tax freeze. And all of it means the same thing. But what it does is it limits the amount of taxes that we are able to collect on a property for your school, along with some other taxing jurisdictions that allow for it. It's not all property taxes. But certain jurisdictions allow for something called that tax limitation or tax ceiling in order to reduce how much property taxes you pay to them at that jurisdiction. Now, this applies to homestead property owners over the age of 65 or disabled who have those exemptions placed onto their account. But what it does essentially is, at the year in which you turn 65 and have that exemption applied to your property, your school tax freezes the amount at which you pay your taxes that year. So for example, for the first year you turn over the age of 65 and have that exemption applied to your account, if you paid $300 for your property taxes that year for your school, and the next year your property tax value goes up, the land becomes more desirable, the value increases, and normally if the value of the property increases, so does the value that you pay for your property taxes. But in the cases of these tax ceilings, there is not going to be an increase from that $300 on your school tax that you paid the previous year. Now, let's say the alternative happens and your property value goes down, or you're able to go and protest the property value lower than your appraised value, and the property tax value reduces. And instead of paying $300 for your property taxes, the bill calculates to $200. You would pay the $200 because we are always going to be able to collect less. However, we would not collect more than the $300 that you were first collected on when you turned over the age of 65. So it is something that we do automatically. You don't have to apply for it. But if you see your bill and you notice that the calculations are not adding up for your school taxes, just be aware that it is probably due to a tax ceiling, tax freeze, tax limitation, whatever word you prefer to use for it. But it is more likely due to that. So it'll normally say it on your bill as well. So you'll be able to check with it, or if you prefer to confirm with someone at our office, we're able to confirm that for you also. Deferrals. I saw a question in the chat earlier, so I hope this answers your question, but a tax deferral is a postponement of property taxes, meaning these bills are still due. Your taxes are still due and being collected on, and if your exemptions don't completely remove any tax responsibility from your property taxes, you are still owing that bill. However, what it does is it allows you additional time in which to pay for those property taxes with a lower interest rate. So as opposed to, say, in February, normally under normal circumstances without the tax deferral, you would still be paying your normal property taxes with penalty and interest. And in February, that penalty and interest is 7%. In March, that's 9%. But with the tax deferral, instead of paying that 7%, 9%, and continuing on forward, you would pay a 5% interest, not penalty, interest per year. And that equates to about 1 point something percent every month. So it does reduce greatly how much you would pay for penalty and for interest in this case, but you do still get collected on interest. It's just at a much lower rate than what you would normally be collected on had you not had a deferral placed onto your account. So what this helps a lot with is whenever folks are over the age of 65, disabled veterans, and they'd like to go ahead and apply for that deferral, is it helps with, the unforeseeable. Should you be out of the state, should you not receive your bill timely and forget about it, should something happen, you have that additional time in which to pay for your property taxes. Now, something that we do like to mention when it comes to deferrals is if should you pass away, your heirs would be responsible for those taxes. Your heirs would have 181 days to pay the property taxes based off of the value at which they are with that reduced interest. However, once those 181 days are up, they would be responsible for the property taxes plus the penalty and the interest as if it had not been placed on the deferral in the first place. So make sure that your heirs are aware whenever you're setting up for a tax deferral. It is a great tool. It does help a whole lot when it comes to paying less over time and having that safety and peace of mind of being able to wait and hold off on your tax payments as need be. But it is something that you want to make sure that your heirs and those who are going to be taking care of the property after you're gone are aware of, so that they're able to make steps. Some folks would rather pay a little bit at a time and, make steps to pay off for those property taxes, while you're still with us, and make sure that they're able to continue with that process afterwards. Because, if you're in tax deferral and God willing, you're living much further than the 65 years of age, those can collect. Those property taxes can definitely go up, and after a while it does become it can become very difficult to maintain. So it's good to make sure that everyone is aware, and if they want to make choices to start making those payments while you're still with us, then they're more welcome to do that. You don't have to own the property to pay the taxes on it. So just keep that in mind. In addition, one more thing that I'd like to add is when you are still making payments on your property, meaning this is a new property that you purchased, you're still paying your taxes through an escrow, or you're paying a mortgage company, or you refinance your property. Some banks do not allow for you to go through a deferral process and to apply for that deferral on that property due to those taxes still being due would signify that although they are the property is still yours, the responsibility of making sure that and ensuring that those bills are paid falls to your bank as well, because then that's their property. They have an interest in that property as well. So just keep that in mind. Speak to your bank representative if that's something that you might be concerned about, but just keep that in mind if you decide to go through with that process of getting that deferral placed onto your account. In addition to deferrals and the tax limitations, there are other options to pay. Some folks are not able to make the full payment at the end of January, and we understand that, to which we have flexible payment plans available for property owners, and that's going to depend on what type of property it is, whether it's a homestead or an over 65. But we have payment plans from 12 to 36 months for homestead properties. It is a financial planning tool. It is something that is able to assist you and help you to avoid collection efforts and foreclosure actions on your property. But it is a tool, meaning that it's not going to continuously be added to your account. But say we're in 2025 currently, we've just finished the 2024 tax year in January. So let's say you're still owing your taxes for 2024. You can have a payment agreement set up for your 2024 property taxes, and that would help you to avoid collection efforts and foreclosure efforts so long as you're able to get that taken care of and have the property payment plan available and on your account prior to the attorneys getting a hold of the account to come this July. But and most of the time that does happen in July. So if you haven't already, make sure that you make your plan to go and set up a payment arrangement so that you're not going to get caught in that predicament later. But these tools are to help, but you do need to make plans for your future as well when you go onto a payment plan. as next year, 2025 taxes will be due at the end of January as they were before. They are not included in that payment plan and we cannot roll them together. So next year, you want to make sure that you're planning now or starting whenever you create, or even before you create your payment arrangement, make sure that you're planning fiscally to be able to pay off your taxes, or at least as much as you possibly can pay on your taxes by the end of January, in order to help avoid that that weight, those foreclosure actions, that collection efforts that do occur to your property when they become delinquent. Just a little bit more information on those payment arrangements. As I mentioned before, the homesteaded agreements are able to do an extended payment plan, so anywhere from 12 to 36 months. Normally, we prefer to do it in years, so 12, 24, 36 months. The terms include a 1% interest per month plus the initial penalty of the month. As I mentioned earlier, February is 7%, March is 9%. April is 11, and it continues to increase. So whatever that original percentage is, plus a 1% interest per month, is how they calculate those penalty and interest. You're still going to be collected penalty and interest on a payment arrangement, but what it does is helps you avoid those collection efforts and those additional fees that get latched onto the account when those collection efforts begin. And that can be anywhere from 15 to 20%, depending on the jurisdiction and the attorneys that take up that collection. So it does truly help a lot, especially when you're able to catch your payment arrangement prior to those attorneys getting a hold of the account. So, keep that in mind whenever you're noticing that you aren't able to pay your bill on time, or if you know come January, I'm not going to be able to pay this entire bill. Pay what you can in January, because whatever you paid to the prior of January 31st is paid without penalty and interest. And then whatever is left after can be placed onto a payment arrangement, so long as any previous payment arrangements have been completed. Meaning, if I have one for 2024 property taxes and I have a payment arrangement set up, I'm not able to set up a new payment arrangement for 2025 until I have completed my responsibility of paying off the 2024 first. So just keep that in mind whenever you're making your plans for your payment arrangement. Other payment plans would include payment plans for land, non-residence, business and commercial property, along with personal property. So those we are not able to have an extended payment plan for. We can do those for 12 months. Your penalty and interest accrue as normal, but it does still help you avoid those collection efforts and foreclosure actions. And again, you can do it on prior or current or prior year taxes. So 2024 previous, any taxes owed between that time, you'd be able to have those onto a single payment arrangement. And with all payment plans, that payment is due by the end of each month. So in February, it's a little short. You'd have to pay before the end of February, but every month you would pay that payment arrangement. So it is a great tool if you need some more time to make that payment. If you pay it off early, there is absolutely no consequence for that. You can pay off your payment agreements early, and we do recommend it. If you have the ability to pay it off early, the more quickly you pay off your payment arrangement, the less penalty and interest you accrue overall, because that 1% for homestead and general payment plans continue to increase. So just keep that in mind. If you pay it off early, there's absolutely no harm in that. But those are the agreement plans that we have. So if you would like to set up for an agreement, please feel free to get a hold of our office and we'll be able to help you and get that started for you. Now, quarterly payment plan is a bit different. Quarterly payment plans are available to our homesteaded properties with over 65 exemption, with disabled exemption, disabled veteran, or surviving spouse of either. So if you have that quarterly payment plan if you have any of those exemptions on your account, you're eligible for that quarterly payment plan, in which that would assist you in taking the full amount of what your tax levy is, what that original amount due is. It splits it into 4 equal payments. And when you split it into those 4 equal payments, instead of paying the lump sum at the end of January, you would pay first quarter at the end of January, the second quarter at the end of March, the third quarter at the end of May, and the fourth quarter at the end of July. So it gives you additional time to make those payments and to be able to financially plan ahead and be able to make your payments timely without having to resort to, if you don't want to do a deferral, if you don't feel comfortable doing so, or if you don't want to go on a regular payment plan, but you also know that you're not going to be able to pay off the entirety of the amount in the first month of January, then you're able to do this quarterly payment plan so long as you have those exemptions on your account. And it does help a lot with maintaining the ability to extend it a little bit further than just paying a whole lump sum in January. You can pay these off early as well, but you have to make sure that at the very minimum, you're paying your quarterly payment. So that is something else that we offer, and you can reach out to our office and we'd be able to assist you in getting that payment plan quoted as quarterly, so long as you reach out to us within that first month of the bill being due. We have multiple payment options. So any of these payment agreements, any of these payment plans, deferral properties, quarterly payments, all of these can be accepted through any of our means of payment here. So you can pay online. You can determine how much you pay whenever you go online and type that in to pay a specific amount. If you prefer to mail in your payment, you're more than welcome to, and that's where that coupon that I mentioned earlier comes into play and comes in handy, so you're able to maintain record of how much you're owing. You can call our automated phone line at the number here, 713-274-2273, in order to make a payment over the phone with our electronic system. Or if you'd prefer to come into a branch office and make a payment in person, you're more than welcome to do so as well. We do have representatives all over Harris County. There's 15 separate branch offices that are able to assist you with taking your payments. So if there is one close to you, you can check on our website and verify which office is closest to you, and you can make your payments that way as well. When it comes to making your payment, please keep in mind that paying with a card, whether that be a debit or a credit card, is required to pay a 2.45% fee due to having to pay with a card and that going through the bank. You can avoid this by paying with an e-check when you're paying online on our website. Alternatively, you can pay with a check in person, check by mail, or by paying in cash in person. So there are lots of different options that you can take whenever it comes to making your payment, and we're happy to answer any questions that you might have about, which method might be best for you and what options are available to you. We are here to help. If you have questions, or if you're uncertain about your situation, or if there's just something going on with your property taxes that you're just not aware of, please feel free to give us a call. We are here to help you, and we're here to help make sure that you're able to make your payment to your property taxes and continue on without additional fees being accrued, within the requirements of the law, within what we are allowed to do. So, feel free to call us if you're unsure of something or if you have any kind of questions. I'm going to check the chat here in a bit to see if there's anything, because I see a couple of notifications on here.
Yeah, there were a couple, and I'll go over those. Oh, but you know what? There was a private message that was sent to me since you're presenting now about the vehicle. What's the process? Or I'm not sure if it's you or Lisa, to explain about passing car title along to a spouse. If one spouse is on record as the owner and then that spouse passes away.
That's
Will
for,
it-
Okay.
How does
that's
that,
for
how
me,
does that
and
transfer?
I'll answer it when we get to the questions.
Okay.
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 So I was able to answer that question about the 5%. So yes, to repeat, when you have deferral on your payment or on your property tax account, you do still pay that 5% interest, but it is a 5% interest per year. It's not 5% interest per month. And truly that is a pretty small amount so long as you're actively in that deferral and you're actively living and residing in that property. But yes, there is still that 5% interest per year. Let's see. When property is passed via transfer on death and both the original owner and the beneficiary are over the age of 65, will the appraisal remain the same after the beneficiary applies for homestead? So, oh, you go ahead, Tawana. I'm not going to interrupt you. Go ahead.
So depending upon when the property changes over to the new owner, if the property owner, let's say that someone passed away in 2025, in 2025 they still would keep their exemptions on the account, even though the ownership changes over to whoever did the transfer. I think it was a transfer on death deed. Well, whoever did the transfer on death. So the exemptions and everything will stay the same on the property, with the exception of the ownership only for 2025. 2026, the new property owner will start their exemptions.
I want to go back to the beginning to some of the other questions, even though I know a couple of you guys have answered some of the questions. These are really good questions that I want to make sure that they're addressed. Is there such thing as clearing title on vacant land? Miss Lisa, I guess that would be you.
Sorry, could you repeat that, please? Sorry.
Is there such thing as clearing title on vacant land?
Yeah, absolutely. It's a pretty common process. Lots of times I've encountered it when, say, there was a vacant lot next to someone's home and they kept that, maybe they had a garden on the lot, they kept it cleaned up. You can absolutely clear title on that.
Okay. When is the application for what is an application for administrator, and is there a fee for it?
Okay, I'm going to take a little bit of time to answer this one. Miss Musetta had several follow-up. I tried to answer that in the chat and she had follow-up questions. So if Miss Musetta wants to, hopefully you're here still. So an application for administration is the process you apply if somebody passed away without a will. So if someone passed away with a will, it's application for probate, no will, application for administration. There is a fee for both of those. But for any court cases, Harris County, actually, everybody, the state of Texas has what's known as a statement of inability to pay. So please pass this information along, because I have encountered some people that didn't know that they were able to have the application to the fee waivers, and they end up paying a lot of money that they could have had waived. So anytime you file a court case, you can apply for the fee waiver. You have to give a lot of personal information. You have to explain how much income you have, how much property you have. It is not a public record; it's kept private, but you do have to show that you were low income. If you qualify for that, you will not have to pay any court costs. So that's a really terrific benefit. I hate when people spend $300 or $400 on court fees when they could have had their fees waived. So if you are low income, please use the statement of inability to pay. You can ask the court clerks for that.
Now, can you verify, Miss Lisa, if the application for administration, much like the probating the will, can that be done without an attorney?
No. You have to have an attorney for application for administration and application for probate. Okay. So the only time you don't need an attorney is if you're doing that affidavit of heirship, which doesn't go through the court, or you're doing a small estate affidavit. Anything else, you have to have an attorney.
And then how do you pass for cemetery plots? Or how does cemetery
that
plots?
I don't honestly know. It's not real estate. It's the little bit I know about cemetery plots is it's a lot more complicated law that applies for it. I would think that you could pass it on through a will. You could not pass it on through a transfer on death deed. And for the small estate affidavit, that most likely would depend upon the total value of all the property. But that's something to ask someone who, it's a very specialized area of the law. So you'd want to ask someone who knows about that.
What needs to be done when a person dies and the property is designated as a life estate?
Okay, so a life estate is almost always designated if someone dies without a will, the house was separate property, and they have children who are entitled to the house. So if you marry someone after you've already purchased a house and you have children from another relationship, they would be entitled to half of the house if you didn't have a will or a transfer on death deed. But your surviving spouse would have a life estate, which means the ability to stay in the house for their life. That would be established once you go through the probate process. So that would be either administration or probating the will.
Okay, we used to use the Miss Myra years ago, and Barbara. We used to talk about Barbara and poor Barbara. So wherever she is, whenever Myra would hear, we would hear the word Barbara.
We're
We would
sorry,
always
Barbara.
laugh. We would always laugh about that. But in the event that someone, Miss Tawana, is married to James, Tawana passes away. God forbid. We're not putting it out there. And James marries Barbara. James dies. But Barbara can stay in the house for the remainder of her life, even though it was Tawana's house with their children. I'm making an example. So is that correct?
Yes,
Okay.
you got it.
All right. I like to give those kinds of examples so people can get an understanding. Like
I appreciate that.
if your
And I
spouse
wasn't,
remarries, then that new significant other can stay there forever,
I
regardless
wasn't
if it's your
around in
parents'
the,
house or not.
I
Yeah.
wasn't around to hear the Barbara story. So I'm glad that somebody brings it up.
Let's see. Okay, you already answered the question about the interest. Oh, no, we had the question about the car title.
Oh,
Um,
yeah. So if your spouse or someone passes away and they had a car title with nobody else on it, you can, if you go through the probate courts, the executor or the administrator of the estate could transfer the car. The Texas DMV will allow you, they have an affidavit of heirship for vehicles. And I think that you include that in the email that you send out, the follow-up
yes, I
email
do.
with all the documents. So
Yes, I
for
do.
whoever asked about the car title, please check your email in a day or two, and you'll get the follow-up email that will include the form you need. And you submit that to the DMV to transfer the title.
Okay.
That doesn't
Um,
require a lawyer or a court for that particular firm. It's pretty straightforward.
because it's transferring outside of probate.
Correct. It's
Right.
transferring through the state, not through the probate court.
Okay. Okay, you answered the question about the Todd. Okay. How does one find if a lien is on an inherited property?
You would want to go, you could try to do your own search. Harris County Clerk has an online search. I know that Shay agrees with me. It is an incredibly difficult website to search, but you can try. There is a website called, I say it in my presentation. I think it's like Text Docs. I'll find it. There is a website where you can actually do your own search. You do have to sign up for an account, but they don't charge you for the account.
I'd I'd say, me personally, I'd say go through a title company.
I
I'd say
agree.
contact the title company. That's probably the easiest way because they can search everything and can find, and they'll know what they're looking for a lot quicker than you would trying to search on the website to,
Honestly,
to
Nia is
find all of that
absolutely
stuff.
right
Yeah.
because I have been doing this for a very long time and I still have trouble searching when I'm trying to find out if there's a lien on a property. So if you can go to a title company, that's your best bet and you can find it. And it happens more than you think. So it's a good idea to keep an eye on that.
Yeah, because there's a whole process when if you, especially if you're trying to sell a property that's got a lien or something on it that's very old, there you got to go to the person that actually put the lien on it. Then you got to get either satisfy whatever debt or whatever that may be there. You have to then show proof that it's been satisfied. You then have to ask them for release of lien for the property. It has to get submitted. It's a lot of work. I mean, it's a lot of stuff that goes along with
There's
it,
a
and you
whole
don't.
lot of stuff.
Yeah,
And there's a lot of things that are not easy to search for that a title company knows how to search for it. Because with clients I've had, liens have showed up that I wasn't able to find, but they were valid liens. So yeah, go
in
to a title company.
in addition to that, that also lets you know if you actually still have clear title to the property or if it's a property that you're trying to buy, if it has clear title or not, because somebody could be trying to sell you property that's not even theirs.
That happens.
So that happens a
That's
lot too.
excellent to say because that happens.
And you never want to purchase a property without going through a title company. It's
No,
me as a realtor talking, you never want to purchase property without going through a title company, ever.
Me, an attorney who's helped a whole lot of people who find out that their titles are messed up, will tell you the exact same thing. Where, someone buys a property from an individual because they don't want to pay all the extra fees and they think it's a simple deal. You don't know if you're getting a good title. You're not going to know if you're getting a good title unless you use a realtor and a title company.
And then getting clear title on vacant land, it's similar to a land that's got a house, regardless if it's got a house or not. Clearing
Correct.
title process is the same.
It is. It is absolutely the same.
Okay. Another question here. It says, does a spouse with a joint name on house requires a transfer on death instead of a will?
If you're talking about the transfer on death deed, you can have that or a will. You don't, it's not an either or thing. A transfer on death deed does the same thing that a will does for leaving a house. I like the transfer on death deed because if you have a transfer on death deed, the person who inherits the house just has to go to the property office with an affidavit of death, their ID, a copy of the death certificate, and the house will be theirs within a very short period of time. If you probate a will, it could easily be more than a year. I don't know about Fort Bend County or Galveston County. Harris County courts are really, really busy, and it could be a few years before you get that clear title. So that's why I tell people to use a transfer on death. But this is a great question because a lot of people think if they owned their house with their spouse, they don't need to do any kind of transfer. And that is absolutely not true. When your spouse passes away, you have to go through a probate or through a transfer on death to get their share of the house transferred to you. We had a lady at our event a few weeks ago in Alief who thought that everything was fine. Her husband had passed quite a long time ago, and she thought everything was fine because they bought the house together, but he still owns, or his estate still owns that 50%. So you need to make sure if you've bought a house with somebody else that you still get a clear title after they pass.
Going back to the question about the lien or trying to search a lien, once somebody has a lien on an asset, how does it stay there permanently until they do the release, or is it something that they have to continuously update?
I believe it's every 10 years that it has to be renewed, but do not trust me on that because I'm not 100% certain. A lien is not permanent. It expires within a certain amount of time and it has to be renewed.
Okay. And the lien on the person's property does not pass with them, not like with what do you call it? Like
Like credit card debt or something?
Like credit card debt and things of that nature. That the lien on the property doesn't. Okay.
Anytime there is something borrowed against a property, so if someone has a reverse mortgage, a home improvement loan, a lien on the property, it stays with the property. It does not go away when the person passes.
Including the taxes.
Correct. Especially including taxes.
I always bring this question up too, and Shay may want to chime in on this part. There are a lot of these little companies that are out there, a lot of social media things that people, we buy tax liens and you could buy this house or you can get this house just by paying someone's property taxes. Can you kind of touch on that? If somebody's had deferred property taxes that are owed and now potentially getting foreclosed on because they haven't paid within the 180 days after someone passes, what happens?
So those property taxes are, like I mentioned before, you do have to pay those property taxes once they've always been due, but with those additional penalty and interest fees after the 181 days that are given in order to pay without those additional penalty and interest fees that begin to accrue afterwards, those penalty and interest fees are still due. If someone else, say not a bank, just random person goes and pays your property taxes, that doesn't transfer ownership. You don't own a property by paying the property taxes. That has to be done as a title. You have to actually transfer that property over and it has to be signed over. And, in the case of someone passing away, that has to go through the probate process. But someone paying your taxes doesn't necessarily mean that the property belongs to them. So like you could be paying taxes on a vacant lot next to you, and that does not necessarily mean that property, that vacant lot next to you, would be your property. But in the cases of those that the property should be going to, the heirs, if you see that someone else has paid your property taxes and you know that you are going to be responsible for those property taxes, you are able to reach out to us and get a hold of our office, and we're still able to have your payments processed in order to be applied to the account as the owners of that property. But as far as the actual transfer of ownership portion of that, it's not going to happen just because they're paying your taxes for you. It's completely A and B.
So thank you for the gift. If you pay somebody's
Yes,
taxes and
thank you
thinking
for.
that you're going to get the property, yeah, thank you for the gift.
Well, they don't want to just say thank you for the gift. They want to go and pay for their property taxes. For instance, say my mother passed away. I'm an only child. My mother passes away. Her home comes to me, and I'm the only heir of her property. So I know in my heart of hearts, and because of I'm the only person who's gonna have the ability to have that property, those taxes are my responsibility. And say someone else comes in, they pay they pay the taxes, and they think that they're getting property, but they're not. I still have to go and pay those taxes timely. I still have those 181 days to pay without penalty and interest. And after those 181 days, I would no longer have that nice 5% per year I have to pay with penalty and interest fees. Penalty and interest is accrued based off of the time in which you pay them. So I don't want to just say, oh, well, taxes are paid, I don't have to worry about it. I want to go in and make those payments for the property taxes, because if I don't and I wait, and they person who paid the property taxes for whatever reason wants their money back, they can take their money back. That's their money. They made the payment in error, and if they want to request for a refund, they absolutely can. And then I'm stuck with a much larger bill because I didn't pay the taxes timely. And that causes even more issues. So if you know that you're responsible for paying those property taxes, make sure that you are making steps to make those payments. Because if it comes back to me and, so and so decides that they want their money back and they no longer want to pay for the property taxes on that account, and they want their money refunded to them, they can do that. But it's my responsibility as the heir, as the owner, that I would need to pay for those property taxes. And if I didn't pay it and I wait until the money gets refunded back, and say it's now December instead of February when they had paid originally, I'm not going to get additional time to pay those bills. I have to pay it based off of the December penalty and interest. And you don't want to wait, because that's just more penalty and interest for you later. So make sure that if you're responsible for them, that you're making those payments.
Now, I thought I was under the impression that if someone pays someone else's taxes, that they basically have to go through a process of filing suit or something to get their money back, that they can't just go and request a refund from the tax office just because they thought they were going to be able to get the property, and now that they can't, then they want their money back. I didn't think they could do that.
There's a process to getting the refund back, but it is a process that they can go through. It's a process that they would have to go and state, hey, they have affidavits that they have to fill out, and the whole process that they have to go through in order to get those funds back. But it's a voluntary payment. So if they decided that they paid it just because they wanted to pay it, then that's a different story. But if they're paying it in error, they say they paid it in error, then that's different. Like they could be saying, oh, I meant to pay this other account and paid this one by mistake. But it's a different process depending on what the situation is. Because if that were the case, then you would never be able to get the payment back on an account that you paid in error. If I made a typo whenever I paid online, it would be a real shame for that payment. That's how they used to do it before, where if you made a mistake and you paid to the wrong account, that's, separate issue. You have to go through a whole process to get that back. But now you can request for that payment to be applied to the correct account as originally intended. Of course, you have to have documentation to show, hey, this is the payment that I wanted it to go to. But it is something that you can do to have the payments applied where they should be. But that's why it's also my responsibility as the owner or the heir to make sure that those taxes are paid, because I want to make sure that I'm paying them at the least amount possible. I don't want to pay penalty and interest for no reason.
Okay, another question here. If you have already gone through probate and have letters of testamentary as the executor, does that mean you have clear title rights to any inherited property?
No, you still need to file a deed. If you're talking about real property, you still need to file a deed. Usually what your attorney does is prepare an executor's deed. And it's a deed where you would sign the deed as the executor of the estate to yourself, an individual owning the property. So that's not enough. There's that final step of preparing the deeds to transfer all the property.
Yeah, because being an executor doesn't make you a beneficiary.
Correct. you can name somebody to be an executor who doesn't inherit anything from you. You know, and people do that. They'll hire a non-family member because they know it's complicated business and let them take care of it. The executor doesn't get you entitled to anything except for managing the estate.
Okay, so post the probate process and you've gone through letters of testamentary, all the other
Mhm.
kinds of stuff. Can someone then later go back and say, oh, so-and-so owed me, now that I see that they passed, now I want to file suit or now to stake a claim on something, or can they do that?
Not indefinitely. There's a limitation of how much time. It's a few years. I'm not going to remember the exact number. I want to say it's 4 years that they have, but there is a time limit. You can't, you know, if depending on the type of estate process, it could be a matter of months to a few years.
Okay. There was a follow-up question I just saw. I went too fast. Hold on. Follow-up question on appraised value on payment on death. Since the appraised value is less than the market value for a person that's 65, when the beneficiary is over 65, gets the property and applies for exemption, will the appraised value be the current market rate, or will the appraised value be up to the 10% of the previous owner?
The Again, it's based on when the uh, original property owner passes away. If they pass away in the middle of 2025, then whatever the values and the exemptions are for 2025 will remain the same. For 2026, the new owner will pay the market value minus whatever exemptions they qualify for.
So if I'm a senior and I have a house, I've had a house, I've gotten all of the exemptions and everything. So now technically my house is appraised at, because of the exemptions, 150,000. But it's really worth more than that, uh, because of the years of the exemptions and the appraisal caps and things like that. If a new person that now inherits the property, they're inheriting it at whatever the actual value is, not the value of what it was when the person passed.
So the first year it stays. The next tax year they pay the market value.
Okay.
All those caps and everything else fall off.
Okay. Ooh.
When someone say you inherit a house from someone who had the 65 exemption,
Mm-hmm.
and you're over 65 when you inherit it, you have to apply for your own exemption. It doesn't
Yes, you
just
do.
transfer over.
Yes, you do.
But at the new market rate, not the market rate that they were
That's right.
having before. Okay. All right. Oh, you did answer that. Sorry. Blah, 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 blah. How do you find a trustworthy title company? Uh, I don't know that I've come across too many untrustworthy title companies. I know that there probably are some that are out there, but I'd say just probably refer to a couple of realtor friends or somebody that you may know and see who they use for title companies. That would be the only thing I could say. I don't know about you guys.
That's
Uh,
what I would say. Talk to a few of your realtor friends and see who they work with. I've, I know that there are people of any type that are untrustworthy, but you just want to ask around, get referrals.
okay. If there is a statute of limitations on a lien and the lien holder has now passed away, how do you get the lien removed?
That is a great question. If the lien is still valid on that, like say, I'm just going to give this example without knowing details. Say the lien expires every 10 years and someone passes away and say year 8. I think you would need to talk to whoever their successor in interest would be. So if it was a business, find out who's running that business now. If it was an individual, you would want to reach out to that individual's family and see what happened with that. Because the lien could still be there. You most likely would need to have an attorney to have it removed. But I would follow up with the business or the individual's family.
After a will is probated, how does the spouse get the title or the deed in their name only?
That's where you would have the attorney draft a executor's deed and you file that with the county clerk's office. And the attorney should do all of this for you. They should know what, I hope that they know to do this. And, if they haven't, you need to tell them, I need a deed. Because that's the attorney's job to prepare that.
And someone's kind of asking really quick if you can go over how do you do a Todd for a house?
A Todd for a house, it's a very easy, it's not, one thing would be to go to texaslawhelp.org. We have great instructions. They were actually drafted by the Earl Carl Institute, and it walks you through the steps for filling it out. You could also just search online for transfer on death deed Texas, but I recommend finding some instructions that will explain it. The instructions written by the state for the form are not that clear.
Yeah, and the Earl Carl Institute is one of our legal service partners too, and they do have a YouTube video that kind of explains like line by line of how you go through and complete a Todd. So I can make sure that I have it included when I send out the email about that. But that's also part of the first part of the presentations about the wills and estate planning, because she goes over all of those documents of what happens, what you need to do to protect your property before you pass. And getting a Todd done is something that you need to do before you pass. It can't be put on a property after someone's passed away.
I'm so happy to hear about that video. I'll have to reach out to them and see if I can put it on our website. I
Okay.
just put the Todd in response to that individual's question, as well as to everyone in the chat, but it will be included in the follow-up email.
Mhm. Let's see. If a property is owned by Harris County, but they left the HCAT record under my name and I pay the taxes, can I get my taxes back?
So this is going to kind of depend on how that ownership property was transferred over to Harris County. So say ownership now belongs to Harris County because of, it was done through foreclosure, or the property was transferred over as part of like an eminent domain type of thing, or it was purchased from the property owner. If the property has not been transferred over to Harris County, because Harris County, once they become owners of that property for whatever reason, that property becomes exempt because it's a Harris County property. It's being used by the government for the government, so they're exempt from property taxes. So they would be refunded whatever payments were done from ownership date and having the payment, or for those 5 years from the ownership that each kid can go back and change it to forward would be changed to exempt due to it being a Harris County property. And then once that happens, then whatever payments had been overpaid would be refunded. Now, it does kind of depend on the situation, and I know we can't be more than like kind of vague on the online form. So if you wanted to give us our office a call and ask for additional clarification on that, that's something that you would want to do to verify, how the transfer happened to come into the ownership of Harris County, along with verifying that information could be returned back, or if you could ask for those payments to be refunded. Because like I said, it is a voluntary payment. There is a process that you have to go through. But if the property is no longer in your name, as in the property no longer belongs to you, it needs to get changed over into Harris County as opposed to, John Smith, in order for that process to kind of get kickstarted. So, but it is something that you'll want to reach out to us for specifically as far as your circumstances and what exactly happened for that transfer of ownership.
Someone had asked a question too about, I guess it would be an HCAT question about changing the name on the tax record. How do you change that?
One more time, please. Was
Changing
that
the
directed at me?
name, the I guess this would be
The
HCAT.
ownership?
It says, how do you change the property to, how do I change the property to my name on my tax bill?
So in order for that change to occur on your bill, it needs to be changed with the appraisal district. And normally that happens whenever there's a change in the deed. That deed name change goes through to HCAD. HCAD logs it in. And then once HCAD has done their process of sending it to us in an electronic tax roll, then our office gets that information, processes it, and then creates the information or applies that information to the account. But we can't just change the information of the owner, without having that electronic tax roll. We aren't able to make any changes to properties, ownership, property addresses. We aren't able to make any changes to exemptions. What we have is what the appraisal district sends to us in those electronic tax rolls. So if it's just something that you've just done recently, and if it's something that's, just recently been processed, within this month, it does take some time for those processes to go through and for those changes to be made on HCAD side. And then HCAD sends those changes to us in a monthly roll. So that'll normally be like the first Friday or so of every month, I believe. But it does take time. So it does normally take, anywhere from like 45 to 60 days for that changing of information to go through, just depending on when those changes happen. But it does take its time. But in order for us to reflect a change of ownership, it needs to come through the appraisal district first.
Okay.
I feel like
And-
Tawana's
I'm going-
speaking.
Juana,
And
do
I
you
want
wanna
to add,
add anything?
if you
to-
purchase, oh, go ahead, I'll let HCAD
No, I
explain.
was just gonna ask if there, as part of the exemptions part, is there any way property owners might expedite that process versus waiting for the deed to come through?
That's what I was about to say. I'm sorry. I had my mute on. I didn't realize. We don't always automatically receive the ownership changes. So sometimes a title company will send the information to us. Sometimes we'll receive the information from the county clerk's office. We try to keep up with information as far as for, when we receive a report. I think it's a specific company that we use to receive those reports of the deed changes. But it is the Harris Central Appraisal District's stance that it's the property owner's responsibility to make sure that our records are updated. Because if something's happened, if you've moved, if you've done construction, if you've done anything to your property and we don't know, we won't know until you tell us, unless someone physically comes out to your property. So just make sure the ownership changes, if like something's happened where the ownership should be updated, then we need a copy of the deed. Sometimes we receive the information automatically, sometimes we don't, but just to make sure everything stays the way that it's supposed to, I would suggest, get a copy of your deed whenever you come from closing, get a copy of your deed and just go ahead and send it to us. And we'll just go ahead and update the ownership.
I was
And
just,
as far as for with submitting an application, okay, so if they're applying for a homestead exemption and they submit a copy of their deed with their application, as long as that document is valid, then we'll go ahead and update the ownership and grant the exemptions at the same time. It's not really who's quicker, because you don't have to wait to get for your ownership to be updated if you're sending us the documents to update it.
HCAD has a really great website, hcad.org, and they have all the forms you need. I would never wait for something to happen. They have applications for change in ownership name. If you've recently bought a home or inherited a home, you want to go ahead and do that new homestead application, and you have to send in, you can do it online. It's a pretty easy form to fill out. You do have to include the paperwork proof, whether it's a deed because you just bought the house, or if you inherited the house, if you used an affidavit of heirship, you have to submit all that paperwork in. But you want to do that as soon as that house is yours.
Okay, only got like two more questions left, because I want to be mindful of everybody's time here, that we're in the chat, that we're over a little bit. So I understand if someone has to actually leave, but I do want to get these last two questions addressed really quick. Someone said that if you are out of state, that complicates the name of the executor. But if you were already the executor and then you move out of state, does that mess up the executorship? If and can you and you can't do certain things. Does that do anything to whoever's the executor if they move out of state when they've been named executive?
The only issue with the executor being out of state, I mean, there's two issues. There's convenience, because there's a lot of business you have to take care of. And if you're not in the state of Texas, you might have to, do a lot. It might make going through that business more complicated. The other issue is you have to have when you are the executor of the estate, you step into the deceased person's shoes. So if somebody was going to sue that, say the deceased person was about to get sued by someone. So say they, they passed in a car accident and there's issues about who was at fault, and there's going to be a lawsuit about that car accident. The executor would need to step in and be that person in the lawsuit, which means you have to have an agent in Texas who can handle that for you. Typically what happens is the attorney who handles the probate has, you name them your agent and they can take care of any business that has to happen in Texas. So it won't mess up your ability to do things.
Okay. Can an executor get money that has been escheated to the state?
I have no
And
personal experience with that, but you should be able to. You would
but
have to show the state that you would have to send letters of your letters testamentary showing that you're the executor, but yes, you should be able to.
that still doesn't make them beneficiaries though, if
No,
they're
you
even if
would
they're
have to
still getting.
handle, yeah, you would have to. So you're an executor, there's numerous beneficiaries. You could go through to get the money that was escheated, you would put it in the estate account so that it would be divided up among all the beneficiaries.
Mhm. And then how long do you have to complete distribution of the estate, assuming that all the beneficiaries agree and are in no hurry to receive?
You can do as long as it takes. And I want to say to all of you who are beneficiaries, please be patient with the executors. Executors have to take care of a lot of business and things don't happen instantly. And it would be unusual for you to finish distribution within a year just because of all of the processes that have to go through. So now you couldn't take this over 10 or 15 or 20 years, but over a few years, yeah, that's completely reasonable. So this is a very good lawyer answer. You have a reasonable amount of time to complete distribution, and that's basically however long it takes.
I thought it was typically they have four years to go through and complete the probate. I mean, the whole
It's
before they close
best.
probate.
Four years is a good rule of thumb. I mean, the thing is, you honestly don't know what all is going to happen. So, say it's a really complicated estate that owed a lot of, let's just see, they owed a lot of back taxes. The executor would need to gather all of the assets, all of the funds, all of the you know, any money owed to the estate, put that in the estate account, and they would have to use that money first to pay any bills that are due before they gave it to the beneficiaries. So a lot of times what I tell people is hang on to those funds for a year because you have to pay taxes for the last year the person was alive. Even if they passed in January, you still have to pay taxes for that year. You have to make sure all the bills are paid. So you want to have a year or so to make sure that everything has been cleared up before you give that money to the beneficiaries.
Yeah. Especially if you have to sell a property and you still got to maintain it until it's sold or whatever. Now
Correct.
you've given out all the money in the bank account and there's no money to pay the bills, on the property.
You
So yeah,
absolutely,
it could definitely take a while.
we
Uh,
always tell people, please hang on to the money for at least a year, if not more, because you want to make sure that everything's been taken care of. Because what are you going to do if you sell the house and you pass the money out to all the family members and then, uh-oh, they had a whole bunch of taxes they owed. You're going to have to come up with that money.
mhm. Yeah. So then does the executor become responsible at that point, or do all the beneficiaries that actually got the distribution?
The executor could legally go to those beneficiaries, but they might not cooperate.
Oh,
I'm
yeah.
using taxes as an example because that's the
Mm-hmm.
one thing that's never going to go away. If somebody passes with a lot of credit card debt and it turned out they had a lower income, the bank may write that debt off. But with taxes, they're going to get paid. That's that the taxes and things owed on a house are never going away.
Yeah, but even with the credit card debt, sometimes they'll send you that letter like it's considered an income to the
Oh,
estate, and
absolutely.
the estate then has to do their final tax return. So all of that needs to be done. There's a
So
lot of
yes,
stuff that's involved with being an executive. And for those people that have multiple family members or what have you, and that always just want to be in charge, I want to be in charge, I want to do this, I want to do that. There's a lot of work that it takes to be an executor of somebody's estate. And there's a lot of stress, from opening up that bank account, you have to file for a tax ID number. You have to, keep everything separate, an allocation that needs to be submitted to the court. And it's a lot of work, a lot of debtors that you're having to contact, and make sure that you get multiple copies of your letters of testamentary, because some people want the original. They don't want a copy or a scan or an email. They want to see an original. So if you only get 2 or 3 certified copies, you're gonna have to go back down to the court to get more certified copies of your letters of testamentary as well. So same thing with the death certificate. Once you get that death certificate, it's got to be an original. Keep it and make sure that the person who's supposed to get it is the one who actually gets it. We had one issue a few years back in one of our workshops where, and really quick, this young lady and this gentleman that she was engaged to hadn't been married. They purchased the house. She was on the deed, but no, take that back. He was on the mortgage. She was supposed to be added to the deed once they became married. He passed away, but she was still living in the house. She was the beneficiary for his life insurance, but could not get a copy of the death certificate because it was not public record, and the parents did not want to give her a copy of the death certificate. So she had to
This
go through the
happens
process.
more. This
She
happens a
had to
lot.
she had to go through the process of getting an attorney so that she can get the copy of the death certificate so that she can submit the claim for the life insurance. But it's a lot of stuff that happens after someone passes away. And there's nothing like trying to handle business and grieve at the same time. And you've got all of this stuff kind of coming at you. Now you have to think about your mental faculties. All of this stuff is going on all at the same time. Um, and you just want to kind of take your time to kind of grieve through that process first. My recommendation would be to take your time to grieve through that process before you start doing anything related to probate and filing applications and having to get things done. And I understand bills still need to be paid. Family members still need to be taken care of, or what have you. You have to go through that, but kind of put some things in place if possible before that actually even happens, like getting that payable on death beneficiary for the bank accounts. So if you know that you've got somebody that doesn't have access to everything else, but they have this money that they're dependent on from you to actually get it done, make sure that somebody has access to those funds after you passed away, so that they can handle that business in the meantime until they've gone to court and gotten letters of testamentary and all that stuff done, because it is a lot of work. It is a lot of work. Someone asked about how do you learn what to do as an executor. I can't remember, but we used to have these books, like books for administration, and I'm gonna have to look. And I don't know.
Some probate courts put them together. My main thing that I would tell you is your attorney should be telling you what you have to do. And if your attorney doesn't tell you what you have to do as an executor, you need a new attorney, because that's their job and you're paying them to do that.
I'm gonna ask someone at HVL. I think Houston Volunteer Lawyers used to have these booklets on responsibilities of an executor or responsibilities of an administrator that we used to give out when we were doing the meetings in person. So if I have them, Miss Mina, I will reach out to you and let you know, and then potentially mail you a copy. If there's an electronic copy, if I find it, I'll attach it to the email when I send it out.
Let me know if you find that, because I'd like to know about it.
But that is definitely something that would be helpful, I think.
But Miss Mina, there are a lot of courts. I know in Fort Bend County, they actually have a letter that explains everything you have to do. And the executor this is some of the courts in Fort Bend County. You have to sign off on it that you understand that those are your duties.
That's a good idea.
I think it's great. Every court should do that.
That's a good idea. Yeah. All right. With that being said, I think those are all the questions that we've got. I know Shay had to jump off, but I want to thank all of our presenters for being here today, to giving us all this information. Shay, Ms. Tawana, Ms. Maple. Oh, there you go. And Ms. Lisa, thank you guys very much for presenting this information to the community. As always, we know that there's, again, a lot of folks out there that still don't know or still need access to this information. And as confusing as it may be, because we're not expecting you guys to be attorneys, please feel free to come back anytime that you guys feel the need to. We are here the second Thursday of each month with information, the most up-to-date information. So please do not rely on what I call the street committee out there and, you know, listening to, well, when I did it and when this happened 10 years ago, and this is what the process was for me and yada, yada, yada. Please get the most up-to-date information as it relates to Texas. There's a lot of social media stuff that kind of goes on out there too, that kind of gives blanket information that's not relative to this state at all. So trust your, do your own research and trust your resources, or be careful of the resources that you choose and make sure that it is relevant. So, and that's what we do. We rely on our expert volunteers to be here to give you guys the most up-to-date information as we possibly can. So I know a lot of things, but I don't know everything. And I don't by any means claim to be the expert. So we rely on these volunteers and we thank y'all very much. So with that being said, you guys will receive a link for the recording of this presentation. You will receive links to all the presenters' websites and all of their information. We have the protest property tax workshop that's coming up next Wednesday at 1:00 p.m. That is going to be via Zoom as well. I will also attach a copy of that schedule. I believe you guys have a few more. Do you guys have a few more meetings that are in person? Tawana, do you know, or Sarah? Because there was a schedule that was out of all of your meetings. So if there are, then I'll make sure that flyer gets submitted to you guys as well, along with the schedule of other upcoming workshops that A Month of Service has for this month. You said there was?
I think there's one more, but I don't think it's A Month of Service though. It's at a
Yeah, I know. Yeah, Miss Mabel gave me the schedule of like where you guys are going to be at in different locations and things. So I want to make sure in case somebody wanted to come in to an in-person session that they've got them to be able to get to it.
It's Fontino Senior Center, and that's at 6600 Bissonnette Street. That's on May the 15th. That's a Thursday, at 10:30 a.m.
Okay. All right. Good deal. All right. Let's see. And the next thing that we've got coming up as part of A Month of Service on Tuesday, we have the beware of contractor scams and how do you avoid them and protect yourself. We know that hurricane season is coming up, and you know lots of folks are going to need to get repairs and things done, and we want to make sure that you have all the measures in place to protect yourself against contractor scams and frauds and things like that. So we'll be giving that presentation on Tuesday and hope that you guys will join us. The City of Houston's Department of Neighborhoods is having the coffee and conversation in Magnolia on the 14th at 10 a.m. And then again at 1 p.m. we have our property tax workshop via Zoom as well. So the calendar of this month's activities will be sent out to you guys as well. Feel free to contact us and let us know if you have any other questions. If there are presentations that we don't currently offer, then please let us know. And we hope that this information has been beneficial to you. And if it has, please let us know that as well, so that we'll know what we continue to need to bring to you guys, or if we need to change something up or provide more information or what have you. So with that being said, thank y'all. You all have a wonderful day or wonderful remainder of your afternoon. I'm sorry?
I said y'all do the same. Thank you.
Thank you. Thank you. Thank you. All right.
Thank you, everybody.
Thank you.
We'll see y'all next time.
See you in a month.
Recording. Stop.